Dionta, you don't have any questions before we start, do you?
No.
Okay, good.
Come on. All right, let's be on the record in case number 2020 CR 75, captioned State of Kansas versus Dionta Washington. Would the parties announce their appearances, please?
May it please the court, the state appears by Assistant District Attorney Taylor Hines via Zoom.
It please the court, Mr. Washington appears via Zoom with counsel Deborah Erickson.
All right, we're here set down for a plea hearing today. Somebody remind me, have we had a preliminary hearing or a waiver?
We have not, Judge, so we need to do a waiver of prelim.
Okay, have you talked to Mr. Washington about that yet, Ms. Erickson?
Yes, Judge. He
Awesome.
understands that he has a right to a preliminary hearing, that at a preliminary hearing, the state would be required to put on enough evidence to show that a crime was committed. And if that occurred, he would be bound over for trial, that waiving that preliminary hearing only waives that.
All right, you understand all that, Mr. Washington?
Yes.
And that's what you want to do?
Yes.
All right, state, you also waive preliminary hearing?
Yes, Your Honor.
All right, I'll find both parties have waived preliminary hearing. I'll bind the defendant over for trial as charged, and I will enter temporary pleas of not guilty on his behalf before we go through this. Ms. Erickson, I assume you waived formal reading today?
That's correct, Judge.
Okay. All right. So, Mr. Washington, now we're going to take up your plea. Okay. So here's how we're going to do this. I'm going to be asking you a ton of questions. If at any time you don't understand one of my questions, tell me that so you and I can talk about it till we're sure we're both talking about the same thing. Okay?
Okay.
If at any time before you answer one of my questions, you want to talk to Ms. Erickson privately, I can send you guys to what's called a breakout room. You guys can talk without anybody else there. You just let me know you want to do it.
Judge, you are fading in and out.
That's my every time I get an email,
Uh,
I lose that. Turn my email off and it still comes in for some reason. But anyway, I'll realize that and I'll try and hear one come in and restart. No? Still no good?
now it's good.
Now it is.
Okay. All right. Just stop me if it goes out again.
So Dionta, the last thing the judge asked you is you understood that he can give you a breakout room if you need to talk to me.
Yes.
Okay.
Okay. All right. So to get started, I have to have you sworn in, Mr. Washington. So if you'd raise your right hand, my court reporter will swear you in.
Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
All right. Mr. Washington, how far do you go in school?
The 12th grade.
You read and write English okay?
Huh?
You read and write English okay?
Yes.
Okay. Now, as you sit here today, look, I know you're in custody, but are you under the influence of any alcohol, drugs, or prescription medicine that might keep you from understanding what you're doing?
Yes.
I don't think he understood everything, Judge, but because you're quiet.
Yeah. So I'm asking if you're under the influence of anything, alcohol, drugs, or prescription medicine that would cloud your mind and keep you from understanding what you're doing.
No.
You feel like your mind's clear today?
Huh?
You feel like your mind's clear today?
Yes.
All right. You know what you're charged with.
Yes.
You understand you don't have to change your plea from one of not guilty to guilty. If you wanted to maintain your not guilty plea, you would have an absolute right to a jury trial on these charges. You understand that?
Yes.
At that trial, the state would have to put on enough evidence to prove you guilty beyond a reasonable doubt. You would not have to prove anything yourself. Ms. Erickson would help you throughout that trial. She would be able to cross-examine and confront all of the state's witnesses, call any witnesses you wanted called, and if they didn't want to come to court, she could use the subpoena power to make them come to court. At that trial, you would have a right to testify. You'd also have a right not to testify. And if you decided not to take the stand, the state couldn't use that against you. In other words, Ms. Hines couldn't get up there and say, well, jury, you should convict him because he didn't get up and tell you his side. You understand all those rights?
Yes.
If we went through that trial and at the end of that trial you were convicted, you would have the right to appeal that conviction to the Kansas appellate courts. If you didn't have the money to do that, a lawyer would be appointed to do it for you. You understand that as well?
Yes.
Now, if we go through with this plea today, there's not going to be any trial like that at all, and you're going to be giving up all of those rights. You understand that?
Yes.
All right. Folks, do you know what Mr. Washington's criminal history is going to be?
Judge, I think that his only criminal history is going to be the convictions in federal custody that he has right now. So he should be just non-person felonies.
Okay. All right. So I'm going to show you here, Mr. Washington, the plea petition that your lawyer sent me.
And Mr. Washington hopefully has a copy of that in front of him and hopefully has a copy of the grid in front of him.
All right. Can you see that on my screen?
Yes.
Okay. And do you have a copy of that there in front of you?
I got one.
Okay. And you just didn't bring it in?
Yeah, because I didn't know what court I was coming to. They didn't tell me.
That's fine. But this is the plea petition that Ms. Erickson went over, right? Is this the plea petition that Ms. Erickson went over with you?
Yes.
All right. Did you feel like you understood everything in it?
Yes.
Ms. Erickson answer any questions that you might have had?
Yes, she did.
All right. Now I'm scrolling up here to this part that says what we call the plea agreement. I'm going to read this to you, and I want to make sure that we're all agreeing that this is what the agreement is. You're going to plead guilty to count one of the information. The state, yourself, and your attorney are going to recommend the standard sentence, and the parties are going to recommend that your sentence run concurrently to your federal sentence of 60 months with the Federal Board of Prisons. The state's going to agree to dismiss count 2, the misdemeanor, and no one will request a fine. You understand that you have court costs and fees assessed against you, and that you be ordered to do a post-release supervision of 12 months.
Judge, right after court costs and fees assessed against you, you broke up a little bit.
Okay. It says you understand that you could have costs and fees assessed against you, and that you would be ordered to serve post-release supervision of 12 months upon release from prison of this sentence. Mr. Washington, is that your understanding of the plea agreement in this case?
Yes.
Has anybody promised you anything other than what I just read to you to get you to plead guilty?
No.
Has anybody placed any force or threats against you to make you plead guilty?
No.
All right. Now, it talks about the recommendations for sentencing here. And as Ms. Erickson mentioned the grid, I'm sure she went over with you what your expected criminal history is, and with this conviction, what kind of sentence you could expect. Is that correct? Mr. Washington, is that correct?
Yes.
All right. Now, until I get a pre-sentence investigation, I won't know exactly what your criminal history score is. So I have to assume you have the very worst criminal history just for today's hearing, so I can advise you the maximum that anybody can get for this crime is. Do you understand that?
Yes.
All right. So the maximum for this conviction that you're pleading guilty to is 17 months in prison and a fine of $100,000 and post-release of 12 months. Do you understand that that's the maximum?
Yes.
Pardon?
Yes.
Okay. Now, with these recommendations for sentencing, you know, when we come back for sentencing, I'm going to listen really closely to what everybody has to say, but I'm not bound by or party to any of those agreements, and I can sentence you to anything that the law allows me to, regardless of any agreement between the parties. Do you understand that?
Yes.
All right. Mr. Washington, do you have any questions for me or Ms. Erickson at this time about anything that we've gone over?
No, sir.
All right. And knowing all this, do you still want to plead guilty?
Yes.
All right. Ms. Erickson, do you know any legal reason why your client should not plead guilty?
No, Judge.
All right. I had the information open, but I closed it and I forgot. Is this a level 5 possession of meth?
No, Judge. It's a level 9 non-person felony for theft of a firearm,
Theft of a firearm. Okay.
which
I
for
should have known
Deontay's purposes does not mean that we're saying he stole the firearm necessarily, but he had possession of a stolen firearm.
Okay. So, Mr. Washington, as to count 1 of the information, which charges you with theft of a firearm, which is a severity level 9 non-person felony, how do you plead, guilty or not guilty?
Yes.
All right. Now I'm going to ask Ms. Hines to tell me what she thinks the evidence would be in this case. I want you to listen closely because when she's done, I'm going to ask you if that's what happened, okay?
Okay.
Ms. Hines.
Yes, Your Honor. On January 18th of 2020, last year, around 1:27 in the morning, KU Medical Center police officers were responding to a disturbance of a large crowd around the area of 900 North 5th Street in Kansas City, Wyandotte County, Kansas, where the defendant, Dionta Washington, was a front seat passenger and asked to step out of the vehicle because of the disturbance that was going on. Once the defendant stepped out of the vehicle, he ran. The officers were able to catch up with him and apprehend him and search incident to arrest. They found a firearm that was later identified to be stolen once the information was run through their system. And that firearm was a black Springfield Armory model MDX 9mm with a serial number MG933-956. And that all occurred here in Wyandotte County, Kansas.
Taylor, could you repeat the serial number again?
Oh, yes, sure. Serial number MG933-956.
Thank you.
Ms. Harrison, anything to add to that?
No, Judge.
All right. Mr. Washington, is that what happened?
Yes.
All right, thank you. I will find the defendant has freely, voluntarily, and innocently changed his plea from not guilty to guilty. He understands the nature of the charges and the consequences of the plea. The state has provided which the defendant has.
I'm sorry. I know what you're saying, but it's not a factual basis.
The state has provided a sufficient factual basis, and the defendant has acknowledged that factual basis. Therefore, I will find that he is guilty of count 1, possession of a firearm, a severity level 9 non-person felony. Pursuant to the plea agreement,
Judge, you're cutting out a lot again. I'm sorry.
pursuant to the plea agreement, the other charges are dismissed. I'm going to order a pre-sentence investigation. Continue this until May 28th at 9 a.m. And we will be in receipt of that document. Other things needed for, one other thing. Mr. Washington, as a convicted felon, it's now prohibited for you to own or possess a firearm and certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives that can be concealed.
So Deonta, he asked you if you understand that you cannot possess a weapon or certain types of knives, dirk, dagger, switchblade, or other cutting weapons. Did you hear that part?
No, I didn't, but I understand.
Okay, so you understand now. Okay, thank you.
All right. Anything else for our record today?
Nothing
Your
for the
Honor.
record. Oh, sorry.
Your Honor, I believe you said the sentencing was at 9 a.m., but I think we agreed to the 10 a.m. slot on May 28th. That's my only
That's correct.
correction.
Right. You had a 9 o'clock already. So it's actually May 28th at 10. I'll get that invite out right away. All right. Mr. Washington, don't forget to send Ms. Erickson an email invite so that she can send you that document we need from you, okay?
Okay.
And Deontay, so you know, it's basic information that I actually have from the affidavit, but send me the email invite anyhow, okay?
Okay.
Okay, thank you.
We are adjourned. Thank you, everybody. We'll see you in a few weeks, Mr. Washington.
Okay.
Amanda, I'm going to go ahead and restart my computer and see if that helps my system here.
Okay, or it might have been noise from CCA because it was kind of different than your normal email cutout.
Okay. All right. And then Miss Erickson, you're back for my 10 o'clock as well, right?
Yes,
All right.
Judge.
I'm assuming that I'll have this solved, I hope. But until it gets
I trust that you will.